TV is very pleased to be joined by the Honorable Robert Drain, a U.S. bankruptcy judge for the Southern District of New York. Judge Drain, thank you so much for being here with us today.
Thank you.
Let's talk a little bit about the proposed Chapter 11 reform, the Commission report. What are some of the major changes that we might be seeing, and where are we in this process right now?
Well, the Commission report obviously has now been out for about a year. It's elicited some formal responses. It's resulted in hearings in Congress. I don't know whether it will ever result in any particular piece of legislation. Usually bankruptcy legislation occurs because of some overarching problem. Conceivably that could happen over Puerto Rico, and other things would go into a bill, using that opportunity. But other than some major cause like that forces people to focus on bankruptcy, I'm not sure that there would be a sweeping bankruptcy reform at this point.
Some of the elements in the report as it is right now, do you think they could be incorporated by judges as best practices at this point?
I think that the report has a couple of overarching focuses that have led bankruptcy judges maybe to rethink how they've approached those particular types of issues. The report was put together not only by very respected people who were on the commission, but there are about 300 other professionals and judges who had input through subcommittees. So I think it's received out in the world as very thoughtful and worth looking at. The overarching theme, I think, that is perhaps most influential in the report is its discussion of secured creditor rights, and the perception that the report conveys that at least in certain respects the law is perhaps is tilted perhaps too much in favor of certain aspects of secured creditor rights, such as when to value secured claims, who gets the upside in the appreciation and value of secured debt, and the assets securing the debt, and also charging collateral for its maintenance and upkeep. I think judges are you can see it in the opinions, perhaps leaning more on reducing those aspects of secured creditor rights. There's a recent opinion by the Fifth Circuit, for example, at the end of this year, of 2015, that did that under 506C of the Bankruptcy Code. The report is also quite helpful to judges because it has a comprehensive discussion of a number of issues where the courts are split, and cites the cases. So it's a good place to turn right away, and does make recommendations which, at least, particularly if you may not have equally balanced lawyers on each side, the judge can think about. If someone hasn't made that point, it's going to be in the commission report probably, is at least something to balance out the arguments that being made on the contrary proposition. And it's also good to be reminded of the need to be consistent, so that there's predictability in the law, and to aim for consistency. Although judges always should keep that in mind, of course.
Absolutely. Well, Judge, of course, we've seen a reduction across the nation in Chapter 11 filings since the recession. Do you foresee that to continue through 2016, or do you think a lot of that depends on the Fed with the rates?
If I knew that, I wouldn't be a judge. I'd be living in Palm Beach and on my retirement savings from my investments. But we have been, over the last few years, in a recovery period. The economy has been reasonably strong in the U.S. at the corporate level, and rates have been so low that people have just rolled over debt. That I think may be changing, at least at the mega company level, where there's tons of debt. It may not be changing at the smaller company level, where I think there's still quite a bit of liquidity, unless the business is bad, obviously. So it's hard to predict. I mean, I've been very busy. It doesn't seem to me that there's been a downtick in filings, but I do see it getting more busy over the last few months, and I think that'll probably continue. There are certain industries that really need to be restructured, either based on marketplace pricing issues, the oil and gas industry, the coal industry, or because they're in fundamental change, like retail, any industry that's moving into just a different delivery system. I was a mediator in a case last year. There was a textbook company case. You think there'd be nothing different about textbooks, but the words book and books are going out of
Right.
they're
Almost obsolete.
So that whole industry, although no one really focuses on it, is going through a restructuring because they're moving to electronic.
Right, everyone's talking about oil and gas, the energy sector.
Right. So the one consistent aspect of bankruptcy practice is there are always companies that are in financial trouble for one reason or another. Shipping industry has been. I've had 3 or 4 shipping bankruptcies over the last year, for example. So. The real question is whether the sort of industry-specific or sector-specific distressed area will expand because of general financial downturns.
Well, Judge Schrader, it was a pleasure to talk to you. Thank you so much for taking
Sure.
time out of your busy schedule.
Thank you.